the National Fair Housing Alliance. Thank you very much for joining us. Our webinar will begin shortly at 2 p.m. Eastern Time. Once the webinar begins, please send us your questions using the questions toolbar section on your screen. And tomorrow we will send you a link to download the presentation. It will include some supporting materials that are going to be discussed today, and we'll ask you to complete a very brief evaluation. Thank you. Our presenters today are Morgan Williams, who is the Director of Enforcement and Investigations at the National Fair Housing Alliance, and Justin Monteiro, who is the Senior Program Director for Enforcement at the National Fair Housing Alliance.
Hello, this is Morgan Williams with the National Fair Housing Alliance. Forgive the technical difficulties here at the start of the presentation. I hope you can hear me now. Thank you for joining us. As you may have noted in the slides that we just walked through, we're here with the National Fair Housing Alliance, a national civil rights organization that is dedicated to eliminating housing discrimination and ensuring equal housing opportunity for all people in the United States. We welcome you all to join, all of you all for joining us today. This training aims to strengthen enforcement of fair housing laws by providing fair housing advocates an overview of discriminatory internet advertising under the Fair Housing Act. We are, this presentation assumes that participants are already familiar with some fair housing basics, including the protected classes under the Federal Fair Housing Act, theories of liability, and the administrative and legal process. A PowerPoint presentation on the topic of basic principles of fair housing laws will be available on NAFA's website for NAFA members who may need any additional background information. Today's presentation is going to focus on 4 topics. We'll provide an overview of Section 3604C, which prohibits discriminatory statements, publishing discriminatory statements. We'll then look at the guidance that has been issued in regards to 3604C. Third, we will look at the Communications Decency Act, which provides some immunity for website operators of online content, and its relationship with the Fair Housing Act liability. And then finally, we'll conclude with an overview of investigations and enforcement as it pertains to 3604C. Initially, we'd like to present an overview of 3604C. Here we have listed several of the provisions of 3604C, which indicates that discrimination in the sale and rental of housing and other prohibited practices, specifically 3604A applies to the refusal to rent or sell a dwelling. 3604B applies to the discriminatory terms and conditions that housing providers may institute. 3604C, of course, the focus of this discussion covers publishing discriminatory statements, and 3604D applies to false representations. There are other substantive provisions of 3604 that go on and talk about reasonable accommodations and modifications and other substantive provisions of the Fair Housing Act. We wanted to sort of detail this slide in order to provide a little bit of context about the specific provision of the Fair Housing Act that we'll be focused on and where it is in the Fair Housing Act, but also to underscore that a discriminatory statement is the basis for a claim or a violation of the Fair Housing Act, separate and apart from a discriminatory act, which may violate some other provision of the Fair Housing Act. So to focus on 3604C and the text of the law itself, which as fair housing advocates or investigators or certainly attorneys is always helpful to go back to directly, states, it shall be unlawful to make, print, or publish, or cause to be made, printed, or published any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on race, color, religion, handicap, familial status, or national origin, or an intention to make such a preference, limitation, or discrimination. So what does that mean? Essentially, there are four elements that make a discriminatory advertisement, or make an ad discriminatory. One, that there's some act of making, printing, or publishing, or causing to be made, printed, or published. Two, that there is a notice, statement, or advertisement itself. Three, that it applies to the sale or rental of a dwelling. And four, that it indicates some preference or limitation based on a protected class. This is essentially what we'll be discussing over the course of the presentation and what exactly this means. 3604 applies to both persons and entities who place real estate advertisements as well as the publishers of those advertisements. Separate liability for separate parties. We flag here on this slide the Communications Decency Act as it provides immunity to some internet providers, and we'll discuss that further. But this dual liability is a critical component to Section 3604C, and it's helpful to think about when thinking about what exactly the violation is that you're looking at when you see a discriminatory statement, because there are multiple parties engaged in having that advertisement being causing that advertisement to be printed or published, and looking at this dual liability is critical. Section 3604C applies to various forms of communication. Courts have recognized that less overt language can unlawfully indicate a discriminatory preference. For example, couples only specifically doesn't indicate that families with children are barred from staying in that rental unit. However, it does clearly indicate a preference for couples, which would generally denote a couple without children. Housing advertisements may be discriminatory if they portray models of only one race or national origin, or they use certain race models to advertise a particular development and not others, or to particular communities and not others. In addition, 3604C applies to a wide range of advertised media and statements. Eligible damages under 3604C, well, specifically compensatory damage claims are limited to the harm caused by hearing or reading the statement itself. Notably, victims of 3604C violations can recover damages from intangible injuries, such as emotional distress. In a seminal case, Reagan v. New York Times, decided by the Second Circuit in 1991, which we'll reference multiple times throughout this presentation, African-American plaintiffs in human model cases may establish a case for damages by oral testimony that he or she is a newspaper reader of a race different from the models used and was substantially insulted and distressed by a certain ad. 3604C has certain limitations and is also very expansive, and we're going to cover sort of the set of limitations and the ways in which it is extensive as a way to provide some overview on 3604C. The limitations include that it applies in connection with a housing transaction. There are some First Amendment concerns, and there's some shared living issues that may need to be accounted for, especially in the Ninth Circuit. To talk about each of those in detail, 3604C violations must be in connection with housing. So these violations only apply to discriminatory statements made in connection to the sale or rental of housing. Note that a neighbor is therefore not typically in a position to violate 3604C by making discriminatory statements. However, they may be in violation of some other provision of the Fair Housing Act, such as 3617, which bars intimidation and other harassment-related activities associated with the Fair Housing Act. Section 34.0c has raised First Amendment concerns. The First Amendment says, of course, Congress shall make no law abridging the freedom of speech. However, 3604c prohibits every discriminatory notice, statement, or advertisement with respect to all housing sales and dwellings. Therefore, 3604c specifically restricts certain types of communication. However, content-based restrictions on speech get the highest level of judicial scrutiny, and this is substantially reduced when the restriction applies to commercial speech. Housing advertisement of the sort that would be called into question in regards to 3604c is commercial speech. And generally, the government can regulate commercial speech so long as the underlying conduct is subject to regulation. So the question of 3604c constitutionality in regards to First Amendment speech hinges on whether the conduct is legal. So put another way, the test to determine whether the First Amendment constitutionality of 3604c stands is whether the defendant's statement was made with respect to unlawful activity. In most cases, discriminatory statements will be regarded as unlawful. There are, of course, a variety of exceptions under the Fair Housing Act. However, other civil rights laws often apply, and therefore, 3604c is regarded as constitutional regulation of speech, of commercial speech, regarding unlawful activity. An additional limit of 3604c is liability in the roommate context. Roommate.com is a case that we'll talk about later in the presentation in regards to the Communications Decency Act and in regards to a prior Ninth Circuit decision. However, in early 2012, the Ninth Circuit handed down a decision in the Roommates.com case which found that the constitutional right to intimate association applies to roommates. The court then turned to the principle of constitutional avoidance to construe the term dwelling. And in doing so, Congress, the court found that Congress did not intend to apply the Fair Housing Act to shared living spaces. This is a Ninth Circuit decision that is binding in courts within the Ninth Circuit, which are those states identified on the West Coast there in the parentheses on the slide: Arizona, California, Nevada, Oregon, Idaho, Washington, and Montana. In essence, liability, 3604c liability under the roommates decision in the Ninth Circuit does not extend to the roommate context. These limitations noted, it's also important to note that 3604c has extensive reach. It applies regardless of intent. It applies to both blatant and subtle statements. And defendants that are otherwise exempt under the Fair Housing Act must still abide by 3604c dictates. 3604c, again, applies regardless of the speaker's intent. The statute only requires that the statement convey a preference or limitation to the ordinary listener or ordinary reader, not that the speaker intended to convey such a preference or limitation. As such, 3604c has been regarded as a strict liability provision. 3604c applies to blatant and subtle discriminatory statements, and we'll talk more about this in the guidance section of the presentation. But subtle messages can be just as effective as blatant statements in dissuading people from attempting to procure housing. And here we have a quote from Reagan v. New York Times, which underscores this. Ordinary readers may reasonably infer a racial message from advertisements that are more subtle than the hypothetical swastika or burning cross. And we read the word preference to describe, as is stated in the statute, to describe any ad that would discourage an ordinary reader of a particular race from answering it. 3604C applies to otherwise exempted properties. The Fair Housing Act applies very broadly in the housing market. However, there's some limits to its application. 3604C has greater reach than other substantive parts of the Fair Housing Act, and then it applies to defendants that are otherwise exempt from the statute. Put another way, there are several categories of defendants who are allowed to engage in discriminatory housing behaviors, but who are still not permitted to make discriminatory statements or to advertise their discriminatory preferences. Some of those exemptions are identified here, of course. The Miss Murphy exemption, which applies to apartment buildings with 4 or fewer units where the owner resides, or any single-family house sold or rented by an owner subject to certain provisos such that the owner does not own more than 3 such single-family houses. And, of course, protecting religious organizations and private clubs from limiting their dwellings to their own members. So noting that 3604B has significant limits and is simultaneously quite expansive, we're going to talk a little bit about what it is meant to impact. And discriminatory ads themselves have a broad function in the housing market that 3604C is meant to address. Specifically, discriminatory ads reinforce the message to the public that it is acceptable to refuse to rent or sell to members of a protected class. And this in itself stops home seekers in their tracks before they ever see a home. In addition, discriminatory ads can serve to perpetuate segregated living patterns. This is a quote from the seminal case U.S. v. Hunter, Fourth Circuit case from 1972, which states that widespread appearance of discriminatory advertisements in public or private media may reasonably be thought to have a harmful effect on the general aims of the Act. Seeing large numbers of white-only advertisements in one part of a city may deter non-whites from venturing to seek homes there, even if other dwellings in that same area must be sold or rented on a non-discriminatory basis. Discriminatory ads can also create the impression that discrimination is legal. Legal housing advertisements, as is stated here in this case, can foster a public impression that discrimination in housing is legal, thus facilitating discrimination by defendants. Notably, millions of dollars are spent on educating the public about fair housing rights. And these ads, discriminatory ads, send the message that housing discrimination is okay. Indeed, to conclude the overview section of 3604C, its functions are outlined here. What did Congress hope to achieve by outlawing all discriminatory housing advertisements, including those made by otherwise exempt housing providers? Well, one, it helps to promote housing integration by ensuring advertisers do not deter minority home seekers, families, children, persons with disabilities, etc. 2, it prevents emotional distress on individuals who are the targets of discriminatory advertising. And 3, it helps to promote awareness that discriminatory housing practices are unlawful. So that's a broad overview of what 3604C specifically states, its elements, its application, its limitations, its expansiveness, and its impact. We'll now talk a little bit about some of the guidance that HUD and others offer in regards to 3604C. Specifically, there are two sources of guidance which we may look to. One is the HUD regulation on fair housing advertising, and a second is a HUD memo on guidance regarding advertisements under 804 or 3604C of the Fair Housing Act, which is a memo that was issued in 1995 and is referred to as the Ockenberg memo. These two pieces of HUD guidance speak for themselves, and I will be drawing information in the next few slides about the content of what this guidance has to say. However, as is the case with all HUD guidance, the ultimate authority on this HUD guidance is HUD itself, and we certainly defer to HUD's reading of these protocols, and they are certainly a resource in helping us understand specifically what is meant under this regulation and this broader guidance. HUD regulations provide some guidance on fair housing advertisements. The purpose of this part of the regulation, of Part 109, is to assist all advertising media, ad agencies, and all other persons who use advertising to publish or cause to be published housing ads which are compliant with the requirements of the Fair Housing Act. The guidance provides background information on various content of statements that may constitute discriminatory statements. They provide added guidance on the selective use of advertising media or content, and they also provide information about fair housing policies and practices that advertisers and others can engage in to mitigate their liability on this issue. Section 109.20 specifically covers words, phrases, symbols, and visual aids. The HUD regulation identifies these various content matters associated with statements that typify those most often used in residential real estate ads to convey either overt or tacit discriminatory preferences or limitations. And there's statements in the regulation associated with each of the protected classes. In addition, the regulations identify that certain phrases in a discriminatory context need to be avoided, such as restricted, exclusive, private, membership approval. The regulation indicates that symbols or logo types that imply or suggest a protected class need to be avoided. The regulation notes concern about colloquialisms or words or phrases that are used locally which may imply a preference. Directions or area descriptions are also cause for concern and noted in the regulation. Section 109.25 of the regulation covers selective use of advertising media or content. The selective use of this advertising media or content is detailed here. Specifically, selective geographic ads, selective use of the equal opportunity slogan or logo, and selective use of human models when conducting an ad campaign may constitute discriminatory advertisement. And this could include strategic placement of billboards, brochures that are distributed within a limited geography, or any number of actions associated with the disparate use of advertisements in regards to protected classes. And finally, in regards to the HUD regulation, HUD notes that in investigation of complaints, it will consider the implementation of fair housing policies and practices detailed here in the regulation as evidence of compliance with the prohibitions against discrimination in advertising under the Fair Housing Act. And this could include the use of equal housing opportunity logos or statements or slogans, the use of human models that are in an integrated fashion, notification of fair housing policies to employees, clients, or in a publisher's notice all may help to mitigate liability associated with discriminatory advertisements. The second piece of guidance that we want to briefly provide some overview on is the Ockenberg Memo. This is a HUD memo that serves to provide guidance on the procedures for the acceptance and investigation of alleged 3604C violations. Specifically, the Ockenberg Memo notes that HUD administrative complaints will not be accepted against publishers regarding advertisements where the language might or might not be viewed as being in a discriminatory context. In other words, the publisher is permitted to presume facts that are stated for the exception to be true. For example, a female roommate wanted. The ad does not indicate whether the requirement for a shared living exception is met. However, publishers can rely on the representation of the individual placing the ad that the shared living arrangements apply to the property in question. Note that if the housing being advertised is actually a separate dwelling unit without a shared living space, the person placing the ad may be in violation. However, again, under the Ockenberg Memo, the publisher is permitted to presume the facts here to establish the exception. Here, another example, housing for older persons. The owner or respondent may be held in violation if the ad indicates an exclusion for families with children if the property does not meet the housing for older persons exception. But again, the publisher is entitled to rely on the owner's assurances that the property is exempt. And these examples underscore the dual liability that we noted at the outset in the overview of 3604C. Again, that liability falls both on, as a general matter, liability falls both on the individual placing the ad as well as the publisher of the ad. However, in instances where an ad is expressing some discriminatory sentiment that falls within an exception, such as gender associated with a roommate or housing for older persons that may be designated as such and fall under the Fair Housing Act exception, a publisher is permitted to rely on the facts stated in the ad and is free from liability and is permitted to assume that the exception holds. If the exception doesn't hold, of course, the individual posting the ad is liable. Want to present some possible discriminatory terms. This is a non-comprehensive list that identifies some terms that may be helpful in searching advertisements for statements that may be discriminatory. The use of this language may on its face constitute a violation of the Fair Housing Act. In addition, the language may be used within a context that violates the Fair Housing Act. It's also important to note that this is not a comprehensive list. There are terms such as empty nester, which may indicate a preference and may not be on this list, but in themselves may establish liability under 3604C. There are other terms that it's important to note may be understood to designate a preference, and in doing so may constitute a violation of 3604C. For example, if a statement indicates that a particular housing is perfect for or ideal for a couple, that statement, perfect for or ideal for, in itself doesn't say that any non-couples or any families with children are not permitted. However, it does indicate a preference, and so it's important to be thoughtful and cautious when thinking about terms that may indicate a preference, and to take into account the context in which those terms are being used. The Ochtenberg memo then goes protected class by protected class and provides examples of ad content that create liability and ad content that do not create liability, to help provide some guidance for housing providers and publishers on what HUD deems acceptable and unacceptable. In regards to race, color, and national origin, a white family home or no Irish would be statements that would be violations of 3604C. However, master bedroom, rare find, desirable neighborhood are all used generally in a context that does not denote a preference. In regards to religion, a Christian home or no Jews may create liability. Ads that use the legal name of an entity which contains a religious reference or which contain a religious symbol may create liability. However, if those ads which are using the legal name of an entity which contain a religious reference also include a disclaimer about the equal housing opportunity practices of the housing provider, then that symbol in itself will not create liability. And again, this is detailed in the Ochtenberg memo. In regards to religion, examples of ad content that do not create liability include ads that contain descriptions of the property, such as an apartment complex with a chapel or kosher meals that are available, or ads with secularized terms or symbols regarding religious holidays. In regards to sex or gender, examples of ad content that create liability includes ad for single-family dwelling or separate unit should contain, essentially ads for single-family dwellings or separate units should contain no explicit reference based on sex. However, commonly used physical descriptions of housing, such as mother-in-law suite, may be appropriate. In regards to disability, certainly a statement that indicates no wheelchairs would indicate a preference that would be discriminatory. However, ads can include descriptions of the property or the services or facilities or the neighborhood or the resident conduct in a way that does not in itself establish violation of 3604C. For example, if there's mention of a jogging trail or a fourth floor walk-up. Concurrently, a description of accessibility features also do not establish 3604C violations. In regards to familial status, examples of ad content that create liability include ads that simply state a preference for adults, couples, or singles, or contain even limitations on the age or number of children. However, a description of the property or the services of the facilities similarly do not establish 3604C liability, such as a two-bedroom describing an apartment complex unit as cozy, or identifying the presence of a family room, and themselves they do not establish 3604C liability. So then we have some questions. I'm looking for a male roommate, non-smoker, no drugs, no children, able to pay rent on time. A second example. I'm looking for a female Christian to share an apartment with the Cedar Hill area, must be living in the Dallas area, no one from overseas. These are examples of advertisements that NFHA has seen, and we put them forward today to ask whether these ads would violate the Fair Housing Act. On their face, under the guidance that we've just detailed, there are statements which create liability. And so this liability is something that would constitute a 3604C violation, both for the individual that posted the ad and in the traditional context of newspapers and other publishers for the publisher of the ad. However, the question of whether these ads violate the Fair Housing Act turns on another issue, and that is whether these ads were published in a traditional print form or whether they were published online by a website operator. And that brings us to the question of the Communications Decency Act and fair housing liability, and concludes our overview of the guidance on 3604C. Of course, if there are questions at the conclusion of the presentation, we're going to have an opportunity for question and answer. And so we welcome questions on either the overview or the guidance that we've detailed here. But we're going to shift gears and talk a little bit about the Communications Decency Act and Fair Housing Act liability, and conclude with some remarks on investigations and enforcement. The Communications Decency Act of 1996 states that a provider of interactive computer services, clearly a term that was written into legislation in the 90s, shall not be considered a publisher of content that originates from third parties. Under the case law, an entity becomes a publisher when it exercises editorial control over content, and we'll talk a little bit further about that. But before we talk a little bit further about the application of the Communications Decency Act in regards to the Fair Housing Act, and what when an entity becomes a publisher for the purposes of Communications Decency Act immunity, I want to note that because lawmakers were interested in facilitating the free flow of ideas on the internet, but also wish to encourage website operators to screen and filter offensive content, they included a Good Samaritan provision in the Communications Decency Act, which states that no provider or user of an interactive computer service or a website operator shall be held liable on account of any action voluntarily taken in good faith to restrict access to or available material that the provider or user considers to be obscene, lewd, filthy, harassing, or otherwise objectionable, or any action taken to enable or make available to information content providers or others the technical means to restrict access to materials described here. What does this mean? Under this provision, website operators are able to screen and filter offensive content. And some commentators have even asserted that the Communications Decency Act can be read to mean that only those website operators that are engaged in filtering offensive content are able to claim immunity from the offensive content. All that's to say, the Communications Decency Act does provide the website operator with some level of immunity, and we're going to talk further about that. But even with that immunity, the website operator is still permitted to screen or filter the content on their website in a way that would promote open housing or restrict discriminatory statements. There's two significant cases that we're going to look at when we talk about the application of the Communications Decency Act to Fair Housing Act liability. The first is the Craigslist case, the Chicago Lawyers Committee versus Craigslist, which was decided in 2008. In that case, the Communications Decency Act protected online information systems from being treated as the publisher or speaker of any information provided by a third party, including discriminatory housing advertisements. In essence, Craigslist, which is a forum for third parties to post, in this case, housing advertisements, was not held liable as a traditional publisher would be because they are simply providing the content that a third party has posted. Therefore, they fall under the dictates of the Communications Decency Act and were regarded as immune from liability. Again, in any instance in which an individual posted a discriminatory statement in regards to housing availability on Craigslist, that individual that was posting the ad was still liable, regardless of the immunity provided to the website operator under the Communications Decency Act. However, Craigslist in that case has been held to be immune from the liability of the third-party poster. In contrast, roommates.com, which was decided in the Ninth Circuit in 2008, and again, this is the same case that created issues regarding the shared living context in the Ninth Circuit in 2012. This is the case, but when it went before the Ninth Circuit en banc in 2008 on the issue of immunity under the Communications Decency Act, the Ninth Circuit held that immunity did not apply to an interactive online operator whose questionnaire violated the Fair Housing Act. In order to use roommate.com, users had to create a profile by answering a series of questions that was provided. The questions themselves were provided by roommates.com. These questions included the user's name, whereabouts, and email address, and also included questions about the gender, sexual orientation, number of children, and whether the children lived with the user. Users were then also prompted to state the type of roommate they were looking for in terms of gender, sexual orientation, and number of children. The court found that the specific questions here meant that roommates.com was not simply posting the content from third-party operators, but was actually helping to generate the content, and as such was not subject to the immunity provisions of the Communications Decency Act. Notably, the court did find that roommates.com in this 2008 decision was immune under the Communications Decency Act for the additional comments portion of the website. And this is the portion of the profile where posters could simply input content without any controls by roommates.com, similar to the format utilized by Craigslist. Here again, in accord with the Craigslist decision, the Ninth Circuit found that the immunity did extend to roommates.com. In the current context of internet housing advertisements and the Craigslist decision and the communications and the extent to which the Communications Decency Act has afforded immunity to online websites. In the context of the Craigslist decision and the Communications Decency Act, you now see rampant proliferation of advertisements in which discriminatory statements are being made. One real strong set of examples occurred in the Post-Katrina and Rita Gulf Coast, in which advertisements on websites were posted that were created for hurricane evacuees. Websites postings included statements: provider will provide room and board for $400 but prefers 2 white females. Not to sound racist, but because we want to make things more understandable for our younger children, we would like to house white children. Here, under the Communications Decency Act, assuming this content is simply provided by a third party without any, controls by any of these website providers, the website providers themselves may be free of liability, but the individuals that are posting the ads may still be subject to 3604C liability for making those discriminatory statements. In 2009, NFHA conducted an investigation with 27 member organizations and identified more than 7,500 discriminatory ads. Common violations included discriminatory statements in regards to familial status, national origin, religion, and sex. As a result of this study, NFHA and its member organization partners issued a report entitled For Rent, No Kids, How Internet Housing Advertisements Perpetuate Discrimination. And in this report, NFHA and its partners call on Congress to amend the Communications Decency Act to clarify that, in fact, online housing providers are responsible for discriminatory statements, and to help mitigate the proliferation of discriminatory statements that are occurring online as a result of the immunity that's afforded to website operators under the Communications Decency Act. Also in 2009, NFHA filed suit against American Classifieds, the largest classified advertisement publisher in the country. NFHA filed this after a year-long investigation that uncovered over 60 discriminatory ads, notably in print and online. The Communications Decency Act interpretation here would have the illogical result of holding American Classifieds liable for the ads it published in the newspaper, but not for those ads it published online. The American Classifieds litigation was settled in February of 2011 for monetary payment and various injunctive relief, including fair housing advertising training for American Classified staff. So we're currently operating in an environment that is increasingly complicated because of Communications Decency Act immunity. And as a result, we want to speak with you some about how to be careful and thoughtful in engaging in investigations and enforcement of 3604C violations. And with that, I'll turn it over to my colleague, Justin Monteiro.
Good afternoon, everyone. So to follow up with what Morgan was saying, enforcement of 3604C claims can present significant challenges. In NFHA's 2009 report, titled For Rent, No Kids, we point out that there is an increasing number of housing ads that are being placed online. However, with the current interpretation of the CDA, it's not likely that interactive websites on which those ads are posted and published will be held liable for any discriminatory content when it's posted by a third party. And one option that groups have resorted to is pursuing enforcement on an ad-by-ad basis. But as our report also points out, this approach can be largely ineffective and burdensome. In that investigation, 7,500 ads were identified, but only 1,000 complaints were filed. Fair housing groups often have limited resources with which to develop investigations, and complaints that are filed without being developed put a burden on HUD, which is statutorily required to investigate complaints within 100 days. If the advertiser is not identified prior to filing, HUD may need to issue multiple subpoenas to obtain the information about the advertiser before it even assigns the case for investigation. And because these investigations can take time, regardless of the entity doing the investigation, whether it's a local fair housing group or if it's HUD, the ad by itself can cause widespread harm. Often the housing opportunity being advertised is no longer available by the time the investigation concludes. And in the meantime, the ad may have been viewed by potentially millions of readers. Consequently, this may cause the public to assume that such statements are legal and permissible, and that housing providers can deny persons based on protected classes. That said, enforcement should be done thoughtfully and strategically. However, there is no formula for bringing a 3604C case. However, there are things you may consider before initiating investigations and bringing enforcement actions. Systemic cases and cases that have large impact on the practices and policies of housing providers may allow for more effective enforcement given our limited resources. Number two, bringing enforcement when the dwelling is covered by the Fair Housing Act leaves room for bringing additional claims when you're filing your complaint. For example, a discriminatory advertisement, when it's investigated, may also yield a 3604A, B, or D claim in addition to the discriminatory advertising claim. Testing and other investigative activities may help uncover those additional claims, as well as information that could help facilitate a timely investigation. Also, consider how your organization has been harmed by the discrimination and plan to divert resources to counteract the discriminatory conduct. And lastly, consult with NFHA, experienced attorneys, and other experts. This may help in the construction of strong cases, help you avoid pitfalls, and reduce the risk in making bad case law. So when developing cases, it can be fairly simple to identify potential violations. Simply doing a Google search across the internet, setting up an RSS feed, or when you're looking at a particular site, using a Control F search, or if you're on a Mac, a Command F search, can bring you to specific phrases that are potentially discriminatory. If you refer to the earlier comments and slides that were shown in the HUD regs that Morgan spoke about, as well as the Actenberg memo, you can find some terms that you can search. You should also pay attention to your local market and issues that may be at play, and any colloquialisms that may be used to express a preference or a limitation where your fair housing office is located. Ads are often posted in more than one location. If you find one advertisement, see if it exists elsewhere on the internet, and compare the language among the advertisements to see if it's consistent. If not, there may be an issue with selectively using discriminatory language on different websites, which could be an issue. Also investigate to see if the advertisement exists in print, which was the case in NFHA's case against American Classifieds. Because systemic investigations can lead to more effective use of limited resources, it may strategically make sense to focus on ads posted by housing professionals, such as real estate agents, property management companies. However, you want to consider the potential impact of any investigation prior to initiating any activity. That is to say, you don't need to limit your investigative activities to these entities, but rather consider the impact that your investigation will have. Use advertisements as a way to interface with a housing opportunity and to find out more information about the advertiser and the housing that's being offered. Use phone numbers, email addresses, and advanced calling to determine what the address of the property is, the type of property, and who potential respondents may be. And in situations in which the housing is covered by the Fair Housing Act, again, testing may be a useful tool for gathering evidence of additional claims that can be enforced under the Fair Housing Act. Lastly, if you identify any bona fides who were exposed to and harmed by the ad, that may assist in developing a strong claim as well. Some statements are discriminatory on their face. However, there may be other statements that are discriminatory in certain contexts. In these situations, testing can help establish if a statement is potentially discriminatory or not. Again, it can also allow you to build additional claims. Prior to testing, you want to make sure you have a way to interface with a housing opportunity whether it's over the phone, via email. It's possible that you may just drop by the housing if it's a managed property or other housing professional that has regular business hours. If there's no contact information in the advertisement, you'll need to do additional research, and as much as we hate to admit, there may be situations when you simply won't be able to do a test. But hopefully, if you're developing systemic investigations, there'll be multiple housing opportunities available through the same housing provider, so the inability to test won't be an issue. Scouting or advanced calling can provide you with information that may also help facilitate the investigation and design future tests. And before you select your testers, make sure you know what protected class you're testing for. There may be multiple issues in one ad, and in some areas, one statement may suggest multiple protected classes are at play. If, for example, you're in an area where marital status is a locally protected class, something like looking for two married adults might be a family status issue, or it could be a marital status issue, or it could be both. As always, when testing, be aware of detection issues when deciding which testers to use, how to design the profiles, and how to structure the test. And also be aware that although a housing provider may be willing to put a discriminatory preference or statement in writing and post it in an ad, they may not be willing to make oral statements over the phone. They may instead misrepresent the availability of the unit to anyone who may be perceived to be of protected class, or the one that's in question in what you're testing. So when doing testing, consider doing match pair tests or wraparound tests in order to prove misrepresentations of availability, differences in terms and conditions, and other violations in addition to the 3604C, which you have documented in the advertisement. However, there's no formula for this, so let the facts of the situation determine how you proceed with your testing. Many investigations can be developed systemically, and when you're developing a systemic case, research your housing provider, identify additional properties they may own, and try and implement some mapping over census data to get a thorough picture of where these properties are located and the environment in which they're located. In addition, as you're looking at these properties, look for specific advertisements that may contain discriminatory language, but it's also informative to review websites for specific housing providers to look for discriminatory statements in application and eligibility requirements they may have listed there. It's possible that this may lead you to not necessarily discriminatory statements, but overly restrictive or what could be viewed as highly restrictive criteria that may warrant additional investigation. Collect and preserve all the advertisements and web pages that you come across to the best of your ability. It can be useful to keep hard copies as well as electronic copies of all advertisements. If you have access to programs such as Camtasia, that should be fairly simple. If you don't, you can try saving the page as a PDF and at the very least taking a screenshot and saving it as a Word document. And lastly, testing, again, can help build your case when you're developing a systemic investigation. In addition to providing additional claims, you can use it to help focus and test multiple properties to determine if the issue is company-wide or if it's isolated to specific properties. And lastly, that brings us to some enforcement. And again, fair housing cases in general are challenging to bring, and 3604C claims are no exception. They can be nuanced, and it can be easy to get tripped up if the case is not carefully crafted and developed. And as I said at the beginning, there's no formula for bringing enforcement. However, one best practice is to consult with groups like NFHA who have experience with these cases, to consult with experienced attorneys and other experts who could be of assistance. Additionally, focusing your investigations on housing providers who may have an impact across a region or across a large group, that is to say developing a systemic investigation, and developing it prior to filing may lead to more effective enforcement. And as with any fair housing enforcement action, fair housing organizations want to make sure that they are counteracting the discriminatory behavior they uncover. In the case of advertising discrimination, it may require education and outreach, but the facts of the case and the discriminatory behavior will ultimately determine what actions are needed in order to counteract the discrimination. Fair housing groups should always identify how the discriminatory behavior frustrates their mission, and equally, they should always document the resources they divert to counteracting any discriminatory behavior they uncover. And that concludes the bulk of our presentation. Just to review, 3 main points that we hope you came away with. At the very least, the Fair Housing Act has powerful provisions restricting discriminatory statements. The CDA interpretations have dramatically turned back the progress of the Fair Housing Act. And enforcement of ad cases present challenges regarding the capacity and the law. And with that, I'll turn it back to Morgan if he has any additional comments to make.
Great. Well, thank you all very much for joining us. That is the substance of our presentation. Again, an overview of 3604C, an overview of the guidance associated with 3604C, some comments associated with the relationship between the Communications Decency Act and Fair Housing Liability, and then Justin's just concluded with an overview of some important considerations to take into account when thinking about investigation and enforcement of 3604C violations. At this stage, we'd like to note a couple of things. One is that there will be several upcoming NFHA webinars on October 17th. There'll be a webinar on effective fair housing outreach and education strategies. And on October 28th, there will be a webinar on training condominium, cooperative, and homeowners associations. These will both be for fair housing advocates. And if you have any questions about these trainings, please contact Diane Cipollone, Director of Training, at the website that's the email address that's identified there. We've covered a lot of ground in a short period of time, and no doubt there will be questions. If you note in the toolbar, there's an opportunity to post questions, and we're just now pulling up some of these questions, and it looks like quite a few have been posted. We'll take some time here to review these briefly and to prepare our some responses to some of these questions. If you have additional questions as we're reviewing these, please feel free to post them in the question box. So the question here, this is an enforcement question, which I think is a good enforcement question because it gets into the complications of internet advertising cases in general. The question is, if you do not have a bona fide individual, is it still strategically better to bring a complaint using organizational standing as an organizational complainant rather than to not file a complaint at all? The issues around an organization, a fair housing organization, bringing any complaint are that it needs to establish standing. In doing so, it must show a frustration of mission and a diversion of its resources, and specifically a diversion of its resources in many circuits to counteract the identified discriminatory conduct. In this instance, there are some important considerations to take into account in the advertising context. One being that the injury that's suffered from a discriminatory ad needs to be documented, and a fair housing office needs to be very thoughtful in how it goes about documenting its injury. Many of the decisions that have been issued, unfavorable decisions that have been issued against fair housing offices in regards to the issue of organizational standing have been issued in the advertising context, and we want to caution all fair housing advocates to be very cognizant of organizational standing issues around advertising cases, which isn't to say that standing can't be established. It's only to say that you need to be very thoughtful. In addition, there are resource and capacity issues that any fair housing office and that HUD itself face when engaging in these investigations. As Justin commented on, there's a need to, in the case of an online advertisement, there's a need to identify the specific individual that posted the advertisement. This can be a challenging task that may require legal action in itself to subpoena information. In instances where you're dealing with a small housing provider, there are certain resource considerations that any fair housing office will have to make in its enforcement decisions, and we'd like to note those, in part because HUD itself faces capacity issues, and those must be taken into account in thinking about how to strategically engage in enforcement actions. There are other issues to take into account in regards to considering an organizational complaint, but those are two that I would note. And it's not a straight answer to the question, but it, I think, underscores some of the issues that really need to be considered in assessing the question. Take a moment here to identify some other questions. This a question here. Can you review the requirements, if any, of advertisers in print ads related to the use of the HUD logo or equal opportunity statement? In responding to that question, I'll note that the HUD regulation that we covered, specifically Part 109.30, covers fair housing policies and practices. And in that guidance, that HUD regulation, HUD notes that it will, in the investigation of complaints, consider the implementation of fair housing policies and practices detailed in this section of the regulations as evidence of compliance with the prohibitions against discrimination in advertising under the Fair Housing Act. And that includes the use of the fair housing logo. And so a reading of the regulation indicates that housing providers as well as publishers are best suited in affirmatively using this fair housing material in order to help shield themselves from liability. A question here is mentioned earlier. NFHA reported enforcement as a relatively inefficient means of addressing discriminatory statements in advertisement due to the large resources requirements in the Communications Decency Act immunity. Do you believe education and outreach to be the most effective method of reducing the frequency of these ads? Along the same vein, is there a history of ISPs like Craigslist cooperating with fair housing organizations in this effort? It's a great question. It gets to the systemic issues that the Communications Decency Act posed and what response we as fair housing advocates can take. One, we can continue to press Congress to amend the Communications Decency Act. Two, in thinking about enforcement and the extent to which it may be ineffective given the resources that are required, we can think about how to target our limited resources in a way that results in systemic investigations that may have some greater impact. Finally, I would note that education and outreach is important. Our next webinar covers effective strategies of fair housing education and outreach. The impact of these discriminatory ads are very widespread in the extent to which they may create misperceptions about the Fair Housing Act requirements. And so it's definitely incumbent upon fair housing advocates to engage in aggressive outreach and education, although NFHA would certainly note that that's probably best paired with systemic enforcement. There's some interest in clarifying the extent to which individuals who are posting the ads, the housing providers themselves, are subject to Fair Housing Act liability, even in the face of the other exemptions that may otherwise cover the conduct itself. One example is the Miss Murphy example. Again, that's an instance in which a housing provider may have some certain number of units and reside on the property or in the vicinity, and may be exempt as a result of certain provisions of the Fair Housing Act in regards to discriminatory conduct. Under 3604C, that housing provider is still barred from issuing discriminatory statements and still liable, even in light of that exception. That's complicated to some extent in the Ninth Circuit under the roommates decision, in which Fair Housing Act requirements do not apply to shared living situations. It should be noted that NFHA reads that decision in a narrow fashion and understands the court to have meant it to apply in a narrow fashion. However, we do note extreme caution in any for any fair housing advocates that are thinking about engaging in enforcement in a roommate context, within the Ninth Circuit or otherwise. Just reviewing the questions here, if you'll bear with us for a moment. Thank you all for submitting these questions. It seems that we've largely covered the substance of these questions in some fashion, but there are more questions coming in. If there's some component of your question that we haven't addressed, or if you have pending questions, please do feel free to send them in. And it looks like there's more questions coming in that we're going to review shortly. There's a couple of questions here that deal with how to engage strategically in investigations, and I'll review them. One is we're located in a big college town and often see ads stating students only, or specialize in renting to college students, or medical graduate students preferred. Have there been any cases regarding potential familial status discrimination in this context? This is a good question, and it raises the issue of what constitutes a discriminatory preference. NAFA's perspective on this matter, and in engaging in investigations on advertising cases, is that it would be best to engage in investigation and enforcement of this particular advertisement, not only on the basis of the advertisement, but also on the basis of whatever sort of additional investigation a fair housing office can develop. For example, engaging in testing on the basis of familial, to assess discrimination on the basis of familial status would be a logical next step in considering enforcement of this advertisement. Certainly, a potential claim with testing evidence that showed practices of discrimination would significantly bolster a claim that this advertisement expressed some discriminatory preference. A claim that this advertisement that expressed some discriminatory preference on its face, absent that testing evidence, would be not as strong, and certainly recommend engaging in investigations to bolster evidence with testing, but also to develop an investigation into something that may be more systemic, that may involve alternate housing complexes by a similar housing provider, or otherwise take into account the pattern of discriminatory practice that may be at play. A couple of just terminology matters, understanding that we're engaged with participants with a variety of exposure to fair housing. There's a question, what is a wraparound test and what is a bona fide? When we use the term wraparound test, we're specifically referring to a test using fair housing testers or mystery shoppers in the housing market, in which a protected class tester is paired with a control tester to assess differences in treatment. In instances where a protected class tester may be given certain treatment and then a control tester given other treatment, a wraparound test is a test in which, after a protected class tester experiences perhaps some form of possible discriminatory treatment, the control tester is then engages the housing provider to, for example, assess whether a unit is still available and assess the terms and conditions that they may be provided in order to establish that the discriminatory treatment was a function of the protected class and not other circumstances that may come into play in the housing transaction. And when we're referring to a bona fide, we're referring to a bona fide individual who may be an aggrieved party in a fair housing claim, in contrast to a fair housing office, which itself may be an aggrieved party in a fair housing claim. there's a question here dealing with seeing possible discriminatory ads which are along the lines of single tenant only and best for one person. And there's a question of whether there's a list of common discriminatory ads or phrases that we could share. One of the slides that we covered in the guidance section of this presentation covered possible statements that may be discriminatory, and this presentation itself will be made available to the participants, so you can reference that slide. So we're going to take a stab at also just clarifying what constitutes a wraparound test, because I think we may have been a little bit jumbled in doing so. Justin, please.
Yeah, and just to preface, so we don't want to get too deep into testing methodology, but in your traditional wraparound test, you'd have a control tester contact a housing provider. Subsequent to that contact, you'd have your protected tester contact the same housing provider, and then subsequent to that contact, you'd have your initial control tester contact the same housing provider again. So you have essentially the control tester wrapping around the protected tester. And the timing and the spacing of the contacts are all contingent on the specific housing provider and the issue that you're investigating. But that's just some clarity on how a wraparound test functions. And if you have specific questions on testing methodology, perhaps you can contact us offline, and we can discuss those after the webinar.
You know, there's one more question here which we'll address, which is there any hope for the Communications Decency Act to catch up to the current internet situation and protections to expand, or any strategy to make that happen? It's a good question, and I think it brings us back to our main conclusion points, which is in regards to discriminatory advertising and its significant online presence and the immunity that's established under the Communications Decency Act, we are in a situation where, in some respects, the purposes of the Fair Housing Act and its provisions are being thwarted. We certainly advocate for a reform of this, and would love to talk with folks further about engaging in that advocacy. NFHA members engage in lobbying activities on a regular basis, and that includes each of our board meetings, which is our next board meeting is this Friday. Board members not only come to the board meeting, but spend a day going to the Hill, and we applaud our board for engaging in those efforts and our other members for engaging in those efforts, and we can engage Dee Dee and Jorge and others here at NFHA who do our policy and communications work to incorporate proposals associated with amending the Communications Decency Act in those ongoing communications. But it also raises the point of challenges that we face in investigating and enforcing these issues, and we encourage members who are going to consider engaging in investigation and enforcement of discriminatory advertisements to do so in a thoughtful and careful fashion, in a way that really strives to produce systemic enforcement. And we're certainly available as a resource to think through approaches moving forward. We're at the 3:30 hour, and we sincerely appreciate you all joining us today, and we hope you found this brief presentation informative. We are a resource to all our members moving forward in thinking through this issue, and we thank you for your time.
Thank you. Goodbye.